Good afternoon, everyone. Thank you for joining us. My name is Jennifer Finley. I'm with the Alzheimer's Association in the Rhode Island chapter, and it is my pleasure to introduce to you Mark B. Heffner, Esquire. He's the founder of Heffner and Associates. He founded it in 1992 to serve the needs of older Rhode Islanders and their families. Mark began the practice of law in 1982 at larger law firms, but in 1988 he experienced an elder law crisis within his own family. This incident made Mark decide that the best way to help fellow Rhode Islanders who are faced with elder law issues was to found a law firm focused on elder law. In this session, basic legal and financial considerations will be discussed after a diagnosis of dementia occurs. Elder law attorney Mark B. Heffner will present answers to questions such as, how can I protect assets if a nursing home placement becomes necessary? What are trusts and powers of attorney? How do I avoid probate? Attorney Heffner will review the legal tools available for the caregiver, as well as destroy myths that prevent caregivers from effectively managing the affairs and protecting the assets of loved ones. Now, following Mark's presentation at 1 o'clock, a box lunch is being offered in the grand foyer over here at 1 p.m., and the lunchtime session begins at 1:30, so you can bring your lunch into the grand ballroom for that session. Thank you, Mark.
Thank you, Jennifer. Yeah. Good afternoon. I first presented to this group, or to this, what was the equivalent of this back then, in 1990. So I have a long history with the Alzheimer's Association. I've been on the board. You can't hear me? Really? Well, that's unusual. Okay. Is that better? Okay, good. That's kind of a cavernous room, isn't it? Yeah. Wow. Wow. Okay. I guess I wouldn't even need this thing. So it's great to be here, and I'm even sporting my Alzheimer's tie, which we got somewhere along the way. So the only modification I'd make to what Jennifer said was we're also going to be looking at people maybe even before the diagnosis of Alzheimer's. So but certainly after there's been some signs and so forth. So anyway, we're going to be as broad as we can. I'm going to go through the slides, and then I'm happy to hang out and answer questions. I find that to be the best way to go. Okay, there I am, and there's a title to the presentation. So I was just getting into the disclaimer, and basically it's for general education only. Everybody's situation is different. And I tell clients, be careful what you read on the internet, because your particular situation, and we'll come to this when we talk about how to consult with an elder law attorney, your situation is going to be different than anybody else's. And I've been doing this type of law since 1988, and there are no two situations that are alike. Again, from the perspective of Rhode Island law, and the rules and practice vary significantly from state to state and are subject to change. That's particularly true with the Medicaid rules. So with that disclaimer. Okay, now this is the sort of like don't leave home without it types of documents, and this is what I was referring to when I was referring to people who had even pre-Alzheimer's diagnoses. So any of us. So there's two types of things that you need some help on typically with healthcare, with advanced planning. One is healthcare decision making, and the other is financial decision making. And they're two different tools. The generic tool, the name for the tool, on healthcare planning is an advanced directive. And they come in two flavors, durable power of attorney for healthcare or a living will. And the difference between the two is with a durable power of attorney for healthcare, you select an agent, a human, to be you when you can't make decisions for yourself. You can't make informed consent decisions. And we always want to see a successor agent. The living will is just a statement of what you want to have happen when you're in a terminal condition. So I think the best practice is to combine the language in the living will with the durable power of attorney for healthcare, because otherwise it's just a one-trick pony, the living will is. All it does is say what's going to happen when you're in a coma, persistent vegetative state, et cetera. It's not going to help in terms of the person just even getting medical information while the person's reasonably healthy, and that's particularly important in an Alzheimer's situation, because you would want to accompany somebody, especially an adult child, to a physician, and technically they're not supposed to disclose any information without some sort of disclosure. I mean, they typically will, and in the spouses they almost always will, but I needed this, well, when my mother was in a nursing home in the 90s, I don't know, 2000s, here I am, lawyer guy with my suit and everything, and they didn't care. I needed the healthcare power of attorney. So this is the better way to go. Select an agent, and then select an alternate agent. And we'll come to, kind of who that should be in a little bit. Okay. The other type of advanced planning that is strongly recommended is financial advanced planning. And basically, people just love to put people's names on accounts, just on a deed, on a bank account, et cetera. There are a number of things about that make it problematic. One, in terms of a bank account, if you put if somebody puts their adult kid on, and that kid gets divorced, has financial difficulties, et cetera, they are an owner of that account. So they're not just on for convenience, they're an owner. And those assets could be attached or could be vulnerable for that adult or that other person. So, and with deeds, it's really bad, because this would bore you to tears, but it has to do with a tax issue and a step up in basis. Yeah. Yeah.
If you have two people on a home with your child and they get divorced, does the child have the right to that entire account, or is two people on it, does the other person have entitlement to half of it, or if it was a divorce situation like that?
So the person gets divorced,
And it's your child.
a child, and that you would have to ask a family law attorney, but all I know is they would be listing that on a disclosure in their divorce. So it's not good. So be very careful about that. We'll do it with small accounts, things that have direct deposits, for example. They're hard to change, but just be careful. The better device is a durable power of attorney for financial matters. Now, it's not typically called a durable power of attorney for financial matters, it's just called a durable power of attorney. But it lists everything that somebody could do for somebody else from a financial perspective that we can think of. And the selection of the agent, again, is very important. It's called the attorney-in-fact. And again, a successor agent. Also important is to determine what powers to provide. So for example, let's say you had a husband and wife who had no children, but they were going to select a nephew or somebody to be the successor power of attorney. We would want to give the spouse broad powers to be able to make changes to the plan. So in other words, one spouse becomes incapacitated, we need to do some adjustments to the planning. If we have explicit powers to be able to do that, then we're able to do that. However, if not, we don't have it. So when you have a more typical situation of you have a husband and wife and trusted children or just trusted children, we'll give them estate and gift planning powers just so we have flexibility down the road with that device. Because I've been doing this since the late 80s. And I think somebody broke the record recently. I had a series of people that came in with documents that I'd done in the 1990s. And somebody came up from 1995, and I think that was a record. But the plans it obviously would change depending on the circumstances, and we would want to have the ability to have that person be able to have authority to do things. So the issue of agent. The issue of agent is, this is not an honor, it's a job. So people, I teach at the law school, and I tell my students this as well, there's a great temptation for parents to put on both kids, 3 kids, whatever. And I tell them if I find that they've drafted something like that, I will seek them out and I will hurt them. Because I think it's my job and their job to counsel people that and if I did this visually, I would have a ball hit in a baseball game to left center field and have the left fielder and the center fielder both converge on the ball and collide, and the ball drops. So no one's really in charge. And banks are very reluctant to use powers of attorney. We'll come to that in a little bit. And if they say 2 people need to be on it, 2 people need to be signing everything. And it's just cumbersome. So people seem to be assuaged when they know that other child can be the backup agent. So I think simplistically about a number of things, and one of them is how you describe these things. And you would have the person, let's say there were children, who was more likely to be paying attention to financial matters, be the financial power of attorney, and the person who's better suited to be the agent or decision maker for healthcare, be the healthcare decision maker. Geography doesn't really matter with regard to the financial. You could have the kid in California and it would work. He or she's gonna have to come out here at one point to do something, but mostly they can do things online and remotely. Healthcare power is a bit of a bias toward having somebody local, but again, it's whoever you envision being in that role. So the takeaway from this is these are jobs. Has anyone served as a power of attorney? Yeah, not fun, right? Yeah. And so you want to be able to have the person with the skill set to do that. And you may have my wife is the oldest of 4 daughters, and she's clearly in charge. And so she was the primary agent for my mother-in-law, both financial and healthcare. But in other circumstances, that person might be good at the financial side of things and fall apart in a hospital. So again, you want to decide on that. So the 2 powers of attorney are just no-brainers to have. And selection of agents is critical, and selection of designated powers is also critical. Now, getting a little more advanced, we get into trusts. And trusts come in largely 2 flavors as well. Revocable trusts, which we call living trusts, and irrevocable trusts, which we call irrevocable trusts. Technically, they're both living trusts because they're created during the person's life, but it's pretty much a given that people call the revocable trust a living trust. So what does that do? In the case of, people do estate planning like we all go to the dentist, like when you have to. And people don't renew them, and lawyers like me are, occupied on a day-to-day basis with other things, so we're not sending out reminders typically. So that's why somebody who did a power of attorney 10, 12 years ago might have problems in having that power of attorney enforced. And you say, why? And that's because the banks and the financial institutions have been burned in the past where they honored a power of attorney, and oops, it turned out that that person is now estranged, and the person revoked that power of attorney and has a new power of attorney. And so they make it difficult, and sometimes very difficult, to honor an instrument that is otherwise legally valid. However, if you have that person as a successor trustee to a trust, or currently serving trustee of a trust, and let's even say it's just a successor, that person's name has already been on that account all that time. So it's much harder for them to deny the existence of that person. So it makes it easier. People like these documents because they avoid probate. In other words, the assets that are titled to the trust then are administered in accordance with the trust and avoid probate. We met with a client yesterday, and everything had been titled to a revocable trust, or the beneficiary designations were there, and so we have no need for probate. Probate is just a huge waste of time and money, for the most part. There are exceptions where you use probate as a tool, but that's sort of the advanced class. But for the most part, it's just this formulaic, ritualistic situation that can be avoided. So the revocable trust as the centerpiece of planning, or the irrevocable trust, as we'll come to, is really what you want. So, as I say, one of the things I can always assure clients about, because they get scared when you say trust, and they envision this, their hard-earned money going into some lockbox someplace, is to say it's really just you or you and your wife with another name on it. It says you trustee versus you. That person, the person who creates the trust, is called the settlor or the grantor, different names they give it, and that person has the power up until the moment they die to revoke the trust, amend the trust, change trustees, etc. So though we're retitling assets, no money is actually, or no assets are actually divested of control. So that's a virtuous thing, except if you're trying to protect those assets in the event somebody needs a nursing home. Because the price you pay for that control is that the assets are exposed. And that's not necessarily a bad thing, but you want to just be very clear about the difference. And that would require an irrevocable trust. Planning for post-death, the will, as I say, requires probate. We rarely will do standalone wills these days. Most of the wills that we do, or almost all the wills that we do, are what are called pour-over wills, which just pour over into the trust. So if there were some random asset subject to probate administration, then that would dump into the trust, which is really the main post-death vehicle. Again, same theme. Think of the agent, a financial agent, And by the way, that person doesn't have to be a whiz-bang. I mean, I've had situations where somebody is, credential-wise, might be better suited to be the financial agent, but they're real busy and they just aren't going to pay attention. Just being reasonably smart and being able to pay attention trumps a lot of just other skills, especially on the financial side of things. But the purpose of this bullet point is to illustrate that theme, the financial person, the agent under the financial power of attorney, the trustee under the trust, should be the same person. And the healthcare person could be somebody different, but the financial person should be the same, and also as executor of the will. And the revocable trust, if funded, will avoid probate for those assets. I've had people come in, and there are attorneys that sort of subscribe to these services that produce these documents, and they come in really big binders. They're usually red. And the trust is 106 pages long, I kid you not. And I asked them, well, what's titled to the trust? And they look at me quizzically. What do you mean? So, okay, you have these bank accounts, you have this house, you have this other real estate. What got titled to the trust? And they pull out the instruction that the attorney had given them on how to do that. And I grew up here in Warwick and, love practicing here because this is where I'm from. And we deal with people who may not have graduated from high school and people that have advanced degrees. None of those people are going to fund the trust. They just aren't going to do it. So we're a little bit unusual in that regard in the sense that we include in the work that we do the funding of the trust, the retitling of the assets of the trust. Sometimes that involves giving directions to the client, him or herself, because they have to actually go on the website. Or in some cases, in the case of a deed, if we're going to retitle a deed, a house to a revocable trust or an irrevocable trust, we do the deed, we record the deed. So the job ain't finished, in my view, until the assets are funded, that are going to get funded to the trust. So, very important. For many of us baby boomers or Gen Xers as opposed to, where's most of our money? Is it in a bank account? Now, where is it? 401k, IRA, retirement account. Okay. Those are controlled by beneficiary designations. Okay. Those are not controlled by, we do not fund those to a trust because we can't, because they're tax vehicles. So you always want to make sure, as part of this, that your beneficiary designations are the people you want them to be. And because, sorry? What, the beneficiary designations are the people you want them to be. Okay, yeah, okay. And I always recommend that people check with the institution, get something in writing, or if it's online, go online and do a printout of it. Don't assume that that you know who they are, because there are tax consequences to this that are beyond the scope of anything we're going to talk about this morning or this afternoon that you need to pay attention to. So same is true with life insurance, though people tend to have less money in life insurance as they're older, annuities, etc. Joint titling, also another reason to avoid joint titling, because that asset actually just passes to the other person. 99% of the time, I'll say maybe 90% of the time. The person who is the joint holder will do the right thing and just put it into the pot, but he or she doesn't have to. So what happens if long-term care is needed? Then Medicare has a limited long-term care benefit, and that is coverage of 20 days of full payment, and then up to 80 days with a copay of now $204 a day. Now, if you have a good Medicare supplement plan, that can often cover the copay. But that isn't the issue. The issue is that people get knocked off of Medicare pretty quickly. They'll often give them the 20 days, and then you have these caregiver planning meetings, and they're told, well, they're not progressing, and which is the contrary to the law, but that's another story. And they will say, as of Friday, this person is no longer skilled. And what does that mean? Well, that means Medicare doesn't pay anymore. You can appeal, and sometimes people win the first appeal, but Medicare is not a long-term solution to this. Medicare is a short-term solution if somebody falls, goes to the hospital, is there for at least 3 days, there's a prior hospitalization requirement, and then comes home. Or, in the case of many people with Alzheimer's I've encountered over the years, it's kind of the final straw. No one has wanted to do what is objectively necessary, which is a placement in a skilled nursing home, but something precipitates that, a fall, some incident like that. Somebody's in the hospital, they go to a nursing home. The nursing homes like Medicare because Medicare reimburses at, I'm told, even a higher rate than private pay. So they like it. So then it enables that transition versus putting somebody in a car and driving them to a nursing home. It takes a burden off the caregiver if that occurs. So public benefits, Medicare, and Medicare is an insurance-based concept, which we'll come to. So that's the end. That's the end of any kind of free care that you get from the government, with a couple of exceptions we'll go over. And now we get into the beginning of the next phase, which is it's just private costs for a nursing home. And so what is the average cost of a nursing home in Rhode Island? What would you think? I'm sorry? 400 a day. That 14,000 a month. Yeah, that's pretty much spot on. That's pretty much spot on. My slide says 10 to 14, but it's really closer to 12 to 14. The state, according to the Department of Human Services, because they pay at a wholesale rate, not the retail rate, is $335 a day, or a little over $10,000 a month. So, but the actual costs are closer to the 12 or 14 that you mentioned. Okay, so what are the public benefits that are available for long-term care besides Medicare, which is a limited benefit? And as I say, Medicare, it's a limited benefit. Theoretically, it has no limit for home care, but good luck with that. It's mostly short-term skilled nursing home stays. Medicaid, then Medicaid does pay for skilled nursing home and a limited amount of home and community-based services. And then there's veterans benefits, the VA home in Bristol. Sometimes there's a contract with the facility. I see that less and less. And there's this thing called the aid and attendance benefits. If somebody served during a period of war, which unfortunately in our history is like most of the time of most of our lifetimes, then they're eligible for that. But that is like Medicaid, where there are limits to assets and perhaps income. So the main source of payment is Medicaid. The most important thing to understand about Medicaid is that it's not Medicare. Okay. My wife, who graduated from law school in our class, ahead of me, by the way, to this day calls it Medicare, and drives me crazy. And I correct her, and she doesn't like it, but I correct her. What's more distressing, though, is when, after I've taught a 14-week course to law students, on the exam they get confused. That makes me feel really sad. But anyway, it's not Medicare, because Medicare, many of us get Medicare. You're never going to be asked about your assets. The only time you're asked about your income is when they figure out, what the Part B premium is. But there is no examination of assets or income. Think of it as insurance. Essentially, it's an insurance-based model. Medicaid has specific criteria. One has to be aged, blind, or disabled. Typically, people who are, in advanced stages of Alzheimer's disease are regarded as disabled. However, I've had situations where it's somebody, and you probably encountered this as well, who has advanced Alzheimer's disease but can walk 3 miles a day. And so that becomes a little more problematic. But for the most part, there's this medical test, medical eligibility test, because the state wants to make sure that person has a skilled level of care need, because otherwise they won't pay for it. And then there are also financial criteria, and that's what we focus on, which is assets, income, and transfer of assets. State to state, it varies a lot. I wouldn't begin to try to do anything in Massachusetts or Connecticut, because I don't know. It's like why I refer out matters that involve Superior Court, because there's rhythms to it. There's sort of unwritten rules. The workers vary, and you want somebody who's really familiar and has a lot of familiarity with kind of the unwritten rules as well as the written rules. So, what are the resource limitations for Medicaid? And then we're talking about a single person. When I do this, I just draw a little T thing on a yellow pad, and on one side I put the excluded assets. Anybody know what an excluded asset is for Medicaid purposes? An example of that?
Why don't you define it? Define it.
What?
Would you define it?
You don't have to spend it in order to qualify. Yeah. IRA, very good. In Rhode Island and in about 9 other states. In most states, they say, what do you mean? It's an IRA, you can go redeem it. The I in IRA is individual. We've been able to make an argument that it's a source of income, and therefore the IRA itself should not be exempt. That's very good. But that's just in Rhode Island, and that's just for now. Yeah. An IRA if it is distributing. So most people with Alzheimer's disease, well, I shouldn't say that, because as you might know, they raised the age at which you have to start taking these distributions. It used to be 70 and a half. Now it's 73. There's talking of raising it still further. So you may have somebody with early onset Alzheimer's disease that hasn't yet started taking distributions. And if I see those people in my office and I think there's any reasonable chance in the future that they take it and they're 69, I might say, take it early. You can take it after age 59 and a half without penalty. You have to start taking it at age 73. So, but we've had many situations, what we call crisis planning, where somebody's at a nursing home, they haven't really done any planning at all, and they are not yet taking distributions from their IRA. We'll have the power of attorney, again, very important, that's why you have the power of attorney, and have the authority to begin to take those RMDs, as they're called. And so far, the Department of Human Services that runs the Medicaid program hasn't said, no, you needed to do that 6 months ago, so long as the asset is distributing. The main asset that people get confused about is the home. The home is an exempt resource. My aunt was on Medicaid for 10 years, and they did not make her sell her house. My cousins were living in there, so the expenses were paid for. And then, I forget when it was, I think it was 2006, they introduced rules that said that, well, we're not going to let people with fancy houses keep them. And I think it used to be, when they did in 2006, $500,000 was the limit. But it's ratcheted up over time. But with the price of homes these days, it's crazy. Typically, the Department of Human Services will go by the assessed value, which is generally less than the appraised value. But we don't encounter this problem too often with single people, unless they got a fancy home in Narragansett or Barrington or someplace, or Warwick Neck. Otherwise, the funds, you have a limit of $4,000. And you can keep a vehicle, and you can have life insurance if it has a $4,000 limit, and a prepaid burial contract, with an actual contract with a nursing home, with a funeral home, that has a maximum of $15,000. You see a lot of cremations these days, so you don't usually bump up against that problem, but that is a limit. Yes, sir.
Funeral expenses, you just touched on it. For myself and my wife, how much money can we put aside that they can't touch for funeral? 15,000.
That's the maximum. Yeah.
For each one of us.
For each of you, yeah. But I can tell you, and there was an article I think in the Wall Street Journal about this recently that echoed something that I'd like to say. Generally, in a planning situation, planning for somebody who has Alzheimer's, who's at home, who's otherwise functioning, especially in a married couple situation, I say pre-plan, but don't prepay. Except you can prepay at the last minute. And funeral homes are like any other industry. They get acquired, and so you have a bank account, but whether they'll honor their commitment that account covers the whole thing despite rising costs is another matter. So I say pre-plan, but don't prepay until I tell you to. That's the maximum. And household goods and furnishings, the technical legal term for that is stuff. Your stuff is, they don't care about your stuff. Yes, ma'am.
I have a question. What do you mean by if intent to return the home?
Sorry, I glanced over that. The statute says that the house is exempt only if the person expresses an intent to return home. my aunt had advanced Alzheimer's disease. If they suddenly had a cure for it and they asked her whether she'd want to go home, she'd say, sure, I want to go home. So it's really a kind of a check the box thing. But technically you have to, and that's something else you want to have the power of attorney to be able to do. The power of attorney who's going to be filling out the Medicaid application, you want him or her to be able to check that box that they intend to return home.
Isn't that usually only for 6 months?
No,
Is that
not,
about the application?
the 6-month thing is if somebody can provide evidence that they're likely to return home, then the state will not take all of their income. They'll allot some income to the cost of the house, but that rarely happens. Okay, then available assets are everything else. So I neglected to put on, and when I give you the slides, I neglected to put on IRAs that they're distributing, which I'll put on this. But everything else is available. So any funds over $4,000, if people have a second home, if they have a second car, they're all available. Let me do the questions at the end. Okay, can we do that? Yeah, because I really want to just kind of get through this, and then we can go back and ask anything you want. So the resources, though, for a married couple are quite different. There is no equity limitation for the community spouse, because Medicaid terminology is you have the community spouse and you have the institutionalized spouse. And there are, in 1988, coincidentally when I started doing this, they passed the last rule that was actually helpful for people, which is a built-in spousal protections. So one of the spousal protections is there is no equity limit to a home. Because on the previous slide it had an equity limit of $700,000. So if you got a fancy house and you're a community spouse, you're still living in the house, so they let you live there. The community spouse resource allowance, community spouse can also have what's called a community spouse resource allowance, or CSRA. That's 1/2 of the total maximum total assets. So let's say somebody has $100,000 in non-IRA accounts, then the community spouse can keep half of that. The institutionalized spouse can keep $4,000 of that, and the other $46,000 is available for spending. And there's a lot that can be done in a married couple situation that can't be done in a single person situation. So, I mean, it's a bit of an exaggeration, but if somebody came into our office in a crisis situation, which would be the person has been discharged to a nursing home and they're going to remain there, and it's a spousal situation, it's unusual that we can't get them, with some maneuvering, qualified for Medicaid pretty quickly. One of the limitations, though, would be if they had made asset transfers. So there's different things you'll hear about this. Clients are always telling me that they heard that the rule is now 7 years or 10 years or whatever. The rule is 5 years. 5 years is the look-back period, the period they ask you about whether you've made an asset transfer, or they'll examine it. And what are we talking about with transfers? Basically, what the rules call uncompensated transfers, basically you haven't gotten anything from it other than the satisfaction of making the gift. So that's why in a pre-crisis situation, let's say somebody who's been paying for their grandchild's college. I will say, and I just did last week, told somebody, make the check out to Rhode Island College, because then we can argue it was done for reasons other than to qualify for Medicaid. So done carefully, it can be done, but for the most part, when the biggest myth about that is that, does anyone know what the current gift tax limitation is? 15. It's $16,000 now. Okay, it used to be 10, but now 16. People think that's a get out of jail free card, and it is for estate tax purposes, federal estate tax purposes. But unless you have over $1.7 million, that's million, you're not subject to federal estate or gift tax. Those aren't my clients, and those aren't people qualifying for Medicaid. So the thing about the get out of jail free card, if you're under that limit, is a myth. But acting on that myth, people will often have come in and they've made these transfers, and we have a problem. And the problem we have is we have an uncompensated transfer of a total, in this example, of 3 kids with $10,000 each, of $30,000.
Are you saying that, so if you gave your kids that money, if your spouse went into the nursing home, they could come back for that?
No. Here's what they could do. Well, what they could do is they say you gave away $30,000. The average cost of an average nursing home is $10,000. So you're ineligible for 3 months, but you have to apply for Medicaid. Many times this happens, and the adult children are in my conference room. I say, what'd you do with the money? And usually the answer, happily, is, oh, we just kept it aside. So we say, okay, now you're going to give it back, because you can do penance and cure the penalty period with that. Medicaid planning, highly individualized. One size does not fit all. And crisis planning, somebody about to go to a nursing home, would involve spend downs. And that's why I say hold off on the paying of the burial contract, because there, especially in a spousal situation, there are some advantages to waiting to do that. But Medicaid works in accordance with the first of a month. So it could be the 31st of the month, and you could go across the street here to this funeral home, Murphy's, in ERCOT, and write a check, or the person, power of attorney, could write a check for up to $15,000 and apply for Medicaid the next day. If you spend down, if somebody has a mortgage, if there's a line of credit on the house, those are the things we look for before we start doing any kind of planning, any kind of transfers. There are specialized annuities. Do not believe, as some people that peddle annuities will try to have you convinced of, that the annuity is some sort of silver bullet that is going to protect the assets for Medicaid purposes. You have to have a specifically designed annuity to do that, but it's available for spouses. What we call reverse half-loaf planning, which means basically we take advantage of what I talked about, which is that the penalty period for let's say somebody hasn't made any transfers at all and they're a single person, and they had $100,000. We might have them transfer the $100,000 to an adult child whom they trust, and qualify and apply for Medicaid. And if we're otherwise eligible, then we assert that there's only a 10-month period, not a 60-month period of ineligibility. And if you give back some of the money, which I irreverently call doing penance, you can shorten that period to 5 months. It doesn't matter that you don't. That's kind of on the advanced side of things, but the point is that there are always things that can be done, especially in a spousal situation, but also in an individual situation. And that's what I just said. There are a lot of opportunities built in. to the law itself, and then we, with our planning, put that on steroids. And for married couples, with single people though, it's also never too late. And non-crisis planning or pre-crisis planning, which is many of you are concerned about, include making transfers and incurring the 5-year look-back period. So people who are otherwise healthy, not healthy, but let's say there's been a diagnosis of Alzheimer's disease, but the person's sitting in the conference room and they're otherwise pretty functional, they got a good support system, and there's a reasonable chance that they're going to make it through the 5-year period. Then sometimes we'll do transfer, even though it's there young.
We moved from Florida, sold the house in Florida, and built an in-law addition here in Rhode Island. We moved in almost 3 years ago. As far as that look back, how does that work with that?
Ask me that afterwards. That's a little technical. Okay. Be mindful of the tax implications of transfers, because basically, from an income tax point of view, they are problematic. Durable powers of attorney with estate and Medicaid planning provided to the agent. Remember I said back at the beginning, the powers you want to have in there? Well, if you have an emergency situation, then you want to be able to have that agent under the power of attorney do what that person didn't do before. And again, it's highly individualized as to what techniques you use. Okay, how do you get started? Arrange for a consultation with a competent elder law attorney. When I first started doing this, I tried to, remember the Yellow Pages? Yeah. I tried to get a listing in the Yellow Pages under elder law, and they said, what are you talking about? Now, the first wave of elder law attorneys, of which I was one, have now, some of them have now made businesses out of teaching former real estate attorneys how to do this stuff. But many times they really don't know exactly what they're doing. So by competent, what I mean is somebody that focuses on this area. We have an initial consultation for which there is a fee. And I got that idea in the early 90s, going to a conference of National Academy of Elder Law Attorneys. And what we do is we send out a questionnaire, have the person send it back. We book out an appointment for an hour and a half. My fee is $400. That doesn't cover my time, but it at least makes a statement to the client that, yeah, this is something that you should pay attention to. And you should take seriously. These half-hour free consultations, they're worthless. So you should expect there to be a questionnaire in advance, a meeting that lasts at least an hour, and some kind of fee for that. How do you find somebody? I'm a CELA, Certified Elder Law Attorney. There are about 500 of us in the country, 5 or 6 in the state. And what that means is it's kind of like equivalent to being board certified. The law doesn't do what medicine does. The law doesn't recognize specialties, except in 9 areas, and of which elder law is one. And it involves taking an exam, which has a low pass rate, which most of us, including me, flunked at least once, peer review, continuing legal education, all kinds of things. So there's a map on nelf.org. If you happen to be in another state, look at that. Having said that, that doesn't mean that in Rhode Island there are only 5 or 6 people that can help you. I know a number of attorneys who are very good elder law attorneys who have either not elected to become CELAs, or maybe they didn't pass the exam the first time, like I didn't pass the exam and they didn't stay with it. but they're still competent. So just because somebody is not a SELA doesn't mean they're not a competent elder law attorney. But they should be somebody who does this stuff all the time. If you want to get in touch with me, that's how you get in touch with me. If you do, make sure you reference the Alzheimer's Association, because we are blessed with more work than we can take in most of the time, but the Alzheimer's Association is near and dear to my heart. So if somebody mentions they heard me here, then we'll be happy to try to accommodate them.